Turner, the immigration barrister at Imperium Chambers, with a short but relevant and topical broadcast regarding the Tier 1 highly skilled litigation. For anyone who does not know, the Tier 1 highly skilled litigation relates to those individuals who have applied, generally for ILR, and who have been refused such leave on the basis of their character and conduct under paragraph 3225 of the immigration rules. The background to this litigation is lengthy. I will try to summarise it, something that is likely to prove tricky given its complexity to say the least. The Tier 1 highly skilled migrants are a group of people who had applied for ILR after completing 5 years residence in the country. The Tier 1 highly skilled route is covered by the points-based system, more on that on another day, which meant that if an individual could show that they had earned sufficient money, they would qualify for leave to remain, subject to them meeting other requirements to the rules. The Tier 1 highly skilled route was a route to indefinite leave to remain, ILR. It was popular and many people embarked upon that route with the hope that they would settle in the United Kingdom. Many people married, had children and integrated into the community. All well and good, you might think. And so it was. Then in 2016, the Home Office decided, without really telling anyone, to put the applications on hold. This didn't cause too many problems. People couldn't travel because their passports were with the Home Office, but they could carry on working. Then, in 2018, the refusals started to pile in, and it was a pile. The basis of the refusals, put shortly, was that there were different figures were given to HMRC and UKVI in respect of their earnings, and in the view of the Secretary of State, this amounted to dishonesty and led to refusals under paragraph 3225 on the basis that dishonest individuals were undesirable for being granted indefinite leave to remain. The Secretary of State jumped to this conclusion without giving people the chance to comment or provide an explanation, such as it was a previous accountant's fault, that the person was unwell, that the person didn't understand the tax, or they were careless or simply made a mistake. The present individuals, in this case, all made applications and were all refused, and they lodged judicial review applications, which led to cases before the Upper Tribunal. Judicial review is a complex remedy, and there were a number of hearings with a number of different outcomes. As the refusals came in, people started switching to applications for settlement long residence, as these carried a right of appeal. At first, the government trumpeted about how right they were to have refused the applicants in these cases, as there were initially very few successful challenges. This soon changed. It had transpired that about 2/3 of all appeals were being won by the appellants and about half the judicial reviews. As is common with such litigation, at some point some of these cases came to the attention of the Court of Appeal. The Court of Appeal heard the matter in a joined case in January and gave their decision in 2019. In short, the appellants won. The Court of Appeal's decision, Balajigari and others, versus the Secretary of State for the Home Department, 2019, EWCA CIV 673, mouthful, found that the Secretary of State had acted unlawfully in refusing the applications on the basis that the individuals hadn't been given the opportunity to comment on the dishonesty allegation that was made in the refusal letter. Balajigari also found that Article 8 was engaged and that the Upper Tribunal may have to consider a fact-finding exercise in respect of further evidence, which is unusual in a judicial review application. There are a number of other gems in Balajigari, and I'll produce another programme on what it actually says at a later date. The Home Office sought permission to appeal from the Court of Appeal. That was declined. It's understood that the Home Office have an outstanding application for permission to appeal with the Supreme Court. All the while, applications have been coming before the First Tier and Upper Tribunal, and I was instructed on 2 substantive judicial review hearings, cases which were found to be arguable, for today. However, at the last moment, the Home Office requested my cases be adjourned and the rest of the cases be stayed. This led to a hearing today, which came for the President of the Upper Tribunal and Upper Tribunal Judge O'Connor. The Secretary of State's argument was that there was a need for a short stay and adjournment in order for the Secretary of State to take a breath and consider the Secretary of State's position, and that if cases were allowed to continue now and results came out and then the Secretary of State reconsidered, that there would be a disparity in results. And this was opposed by the applicants, who'd been waiting a very long period of time, on the basis that there's extensive delay. One of my clients is abroad and wants to return, and the other is unable to work. The President noted in particular, and this is what I'll concentrate on, the fact that individuals didn't have the right to work, and questioned the Secretary of State as to whether they would be given permission to work. The Secretary of State's response was that each case would be considered on its merits, and it was open for the individuals to write to the Secretary of State and seek their bail to be varied so that they could work pending the outcome of the litigation. Well, where does that leave us? That leaves, where does that leave the individuals? That leaves them in the position where, given what was said in court today, if you fall within the Balajigari type cases, you've got an outstanding application and you don't have the right to work, you can write to the Secretary of State and ask that your bail be varied and that you be given permission to work pending the outcome of the litigation. This is very important. I've done this before for a client and we were successful, and the client was able to carry on working, and as far as I'm aware is able to carry on working. What it means is that you will need to get in contact and put forward as much evidence as possible to explain why you need to work. Now, that might sound quite simple, but in reality the Home Office is averse to giving individuals who don't have leave the right to work, as it's seen as being against the principle of the rules, i.e. those that don't have leave shouldn't be allowed to work. So my advice, really, which brings me to the end of this short programme, is that if you fall within the Balajigari type of cases, please get in contact with your lawyer, please get in contact with your representatives, or get in contact with me, Paul Turner, the immigration barrister at Imperium Chambers, and we will help you put forward an application for you to have the right to work given to you so that you can work whilst this litigation continues. I can be contacted and Chambers can be contacted on 0207 242 3488 or at clerks@imperiumchambers.co.uk, or simply click onto my website, the immigrationbarrister.co.uk, and send me a message and I'll see if I can help. Anyway, I apologise for the shortness of this broadcast. I hope it's been of some use. Please do not hesitate to get in touch. Once again, this is Paul Turner, the immigration barrister at Imperium Chambers. Thank you, good night, and have a lovely weekend.